Welcome to the second in our webcast series on representing juveniles at sentencing in adult court. I'm Vanessa, Antoun, Resource Counsel for the National Association of Criminal Defense Lawyers, and today we're presenting the series to you in partnership with the Juvenile Law Center, the National Juvenile Defender Center, and the Campaign for the Fair Sentencing of Youth. It's presented with support from a grant from the Foundation for Criminal Justice and the Ford Foundation. So we are very pleased to be presenting this series to you. In addition to what we're showing today, we will continue on, so please save the date for September 25th and September 26th, where we will be presenting additional information on representing juvenile defendants, including using the adolescent research in all stages of the proceedings, placement decisions, and tips on communicating with your juvenile clients. Today, for our session on resentencing of juveniles post-Miller and homicide cases, we have two excellent speakers that are going to help you with that issue. Seated to my right is Paul Mones. Since 1980, he has focused his legal practice and expert consulting on criminal and civil matters related to children's rights, including child sexual abuse, patricide and matricide, general teenage homicide, the mental health treatment of children, and adolescent and domestic violence. The primary focus of his civil work has been on litigation against institutions in which children are sexually abused. Paul began his child advocacy career in West Virginia in 1980, where he was the executive director of Juvenile Advocates Incorporated. During his years in West Virginia, Paul vigorously litigated against institutions which mistreated children and teenagers, and in the process gave a voice to a population which had been largely neglected by the justice system. And during 3 short years, he argued 7 cases before the West Virginia Supreme Court concerning the rights of teenagers in the legal system and in the state. Paul lectures nationally on youth issues to numerous professional organizations such as the ABA, American Psychiatric Association, and the American Psychological Association, and the National Association of Juvenile and Family Court Judges. Seated next to Paul is Stephen Harper. Stephen serves as co-coordinator of the Capital Litigation Unit in the Miami-Dade, Florida Public Defender's Office. He is primarily responsible for the gathering and presentation of mitigation evidence in capital cases. From 1989 to 1995, he served as the chief of the Juvenile Division. In 2002, he took a 2-year leave of absence to coordinate the Juvenile Death Penalty Initiative, a project ending with his oversight of the drafting and filing of the amicus briefs in Roper v. Simmons. In 1998, he received the ABA's Livingston Hall Juvenile Justice Award for outstanding dedication to advocacy on behalf of delinquent youth. In 2005, he received the Southern Center for Human Rights Frederick Douglass Award for his demonstrated brilliance and tenacity in defense of human rights in the criminal justice system, and for his work in ending the juvenile death penalty. Stephen currently teaches courses in juvenile law at the University of Miami School of Law. So I will turn it over to our accomplished panelists.
Thank you. What we're going to do, I'm going to talk a little bit, and then Paul's going to talk a little bit, and then we're going to go back and forth, and we'll take some questions. One of the things I realize about this is that most of the lawyers who are going to be representing kids in this situation are adult lawyers. And so I want to talk a little bit about adolescence and what adolescence means. The other thing I want you to think about is that notwithstanding what the Supreme Court has ruled in 3 cases, Roper, Graham, and now Miller, most judges and prosecutors who A, don't know about kids because they don't normally work with kids, and B, are predisposed to somebody who murders somebody to sentence them to life without the possibility of parole. So you have to basically educate them on what it means to be a kid and how different kids are. The Supreme Court, in my experience, knows more about the difference in kids than the trial court and prosecutors. So that's something you have to always be aware of. And I don't know how many folks out there have actually worked with adolescents. I know that those of us that have adolescents know that they're very different than adults. But I want to just read to you a little thing that we prepared in the Roper case when we were trying to litigate and advocate on behalf of kids. I'm going to talk a little bit about adolescence. I'm just going to read this, so bear with me, but I think it's important for those of us to rethink about what it means to be a kid, and also for many of you, this will be a reminder, and for many of you, this may be new. The sciences have long known that adolescence is a transitional period of life where cognitive abilities, emotions, judgment, impulse control, and identity, they're all still developing. Teenagers, by their very nature, are less mature, less able to assess risk. They don't make good decisions, and they certainly don't control their anger. Similarly, they're more susceptible, far more susceptible to peer influence, pressure, and other external influences. And these traits are particularly common amongst troubled youth who become embroiled in our justice system during adolescence. The abilities of these youths to survive adolescence with their life prospects intact are also affected by learning disabilities, behavior disorders, mental illnesses, abuse, neglect, and trauma. There have been some really interesting and fascinating developments in science recently. And the MRI has shown us, and this has tremendous implications all over the place, but that the adolescent's brain is less developed than the adult's brain. There are the aspect components of the brain, the prefrontal lobes and the temporal lobes. Those parts of the brain are the last parts of the brain to develop. And those parts of the brain regulate self-control, emotions, judgment, intelligence, identity, all the kinds of things that lead to crime and that make kids different than adults. And I think that's very important because when I started practicing in juvenile court, we had like an hour lecture on how kids are different. And that was it. After that, we just proceeded as if the kids were adults. But I remember being told specifically that children's brains are fully developed by age 14. And so after that, it's really a question of experience which makes them different, but not biologically different. We now know that not to be the case. So the other thing I would encourage you to do, again, is to read the cases. Read Roper, read Graham, and read Miller, and use those cases in court because you're going to have to convince the judge and the prosecutor that kids really are different. And in Roper, at least the first case, there are these three specific findings of the court. One is that children have a lack of maturity and an undeveloped sense of responsibility. That's pretty important. And those qualities, the court says, often result in impetuous and ill-considered actions and decisions. The second holding or finding of the court is that juveniles are more vulnerable or susceptible to negative influences and outside pressures, including, in particular, peer pressures. And this is explained in part because of the prevailing circumstances that juveniles have less control or less experience with control over their environment. Kids don't control their environment like adults do. The third characteristic, which I think is very important in this instance, is the characteristics of a juvenile is not as well formed or fixed as that of an adult. The personality traits of juveniles are far more transitory than adults. And so it is less supportable, says Roper, to conclude that even a heinous crime, and that's important, even a heinous crime, the court goes so far to say that, committed by a juvenile is evidence of irretrievably depraved character. And so culpability and blameworthy is diminished to a substantial degree by reason of youth and immaturity. That's the language from Roper. And I think you need to be able to say, okay, kids are less culpable, and as we always used to say, kids are different. And you need to start there, and you need to be able to convince prosecutors, and you need to be able to convince judges that you're not just making this stuff up. The Supreme Court has held this not only, and you have to obey the U.S. Supreme Court, which in Florida is sort of an arguable issue whether the Florida courts do that or not. But clearly, the court is right that kids are different and kids have to be treated differently. And the reason for that is not just what the court says, it's because science tells them that. Okay, so what do you do now? You have this Miller case is in front of you. Kids are different, you got that. How do you prepare for a Miller resentencing? And I just we touched upon this the last talk, and some of you may be tuning in and watched the last one, so I'm going to repeat myself somewhat, but just some general issues that you need to always think about when you're preparing for a Miller resentencing. First question, not necessarily in order, but were his sentences consecutive or concurrent? I have clients where they were sentenced for a murder, aggravated assault, kidnapping. Were those concurrent or consecutive sentences? That has an important effect, or could have an important effect. How many different cases did he have? What's the law in your jurisdiction? What was the law at the time that he was sentenced in your jurisdiction? How much gain time is he entitled to if he's not sentenced to life, a mandatory life without the possibility of parole? In Florida, people who were sentenced to 20 years ago would get more gain time than they would get now. Now they have to serve 85% of their sentence. How old was he at the time of the crime? There's a very significant difference between somebody who's 17 and somebody who's 14 or 15. In fact, there's a 12-year-old being tried for first-degree murder in Jacksonville, Florida, right now. I think you're involved in somewhat in that case. The other thing is, who's the judge? Very important. Is the judge sympathetic? Does he know about kids? Is he sympathetic to what you're telling him, or is he just saying, no, 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 we're going to have a sentencing hearing, and I'm going to sentence him to life without the possibility of parole again? Who's the prosecutor? Do they know about kids? Are they sympathetic? What does the victim's family think now? That's a really critical point. We talked about this in the last session, but the victims could change. And you need to be able to approach the victims, talk to the victims, and get them to have some sense of the fact that this was a kid. And it was not as horrible as your loss was. This was a kid, and he's changed significantly. We also talked at length about the discharge plan. You have to have a discharge plan to present to the court, because the court needs to know that he can release this child at some point and everything's going to be okay. There's going to be structures in place to make sure that he's okay. The other thing, you need to talk to your client extensively and find out what his attitudes are. Has he grown? Has he changed? Is his understanding of what he did much more grown up, much more profound, and he feels remorse? I mean, one of the things that I hate about this business is that oftentimes a kid will come in and the prosecutor or the police officer will say he showed no remorse. Well, kids showing remorse is different than adults showing remorse, in part because kids are developing a sense of remorse and the sense of what that is in adolescence. And so an adolescent who doesn't show remorse doesn't necessarily mean that he will never be remorseful. They grow into that. And you need to talk to your client and figure out how badly does he feel about what happened. Another thing you need to look into, was there a plea offer? I have found that many juveniles, because they don't have the same sense of reality that adults do, that life without parole means life without parole. That's a concept that many adolescents can't even get their handle on. So they were offered, I have a client who's offered a plea of 20 years, and he rejected it. And he went to trial and he lost, and he was sentenced to life without parole, mandatory sentence. And so he now understands what life without parole means. But you need to look into whether there was a plea, and that will take you a significant difference in trying to resolve this case with the prosecutor. Look, he was originally offered a plea of 20 years, but you didn't give it, he didn't take it, and you can explain to the prosecutor the many of the factors involved in adolescence that would make him not take it. And then we get into a part of this, Paul's going to talk about this at some great length. The interesting thing about Miller cases and some of the differences between Miller cases and Graham cases is that in Miller cases, the judge can sentence your client to life without the possibility of parole, but only after a sentencing hearing. So you really have to prepare in a detailed way for that sentencing hearing. And the court outlines some of the factors that you need to be considered, and they're very similar to a lot of the mitigation that we present in death penalty cases. And so I will tell you, you need to have a team put together to deal with these cases. And the team, and I tell you this is what I would think you need. And now I know a lot of you have, like my office, the public defender's office, you tell my boss what you need, and he laughs and he says, I'll give you some of that, maybe. But I think you need to be able to try to have this concept in mind and do what you can to create this. One is you need a lawyer who knows about mitigation, who basically a capital lawyer. who has done mitigation, who's done mitigation works up, who's presented mitigation to the court, who knows what works, who knows what doesn't work, and who has a sense of what the most powerful way of presenting that stuff is. You also need a juvenile lawyer. You need somebody who understands the many ways which we sort of talked about, which kids are different, and how those differences affected their behavior, their decision making, etc. Because most of the capital lawyers and the adult lawyers who are representing these kids, like I said, don't know or haven't thought about in a while what all the many differences in being a kid. The third person that you need on this case is a mitigation specialist, somebody who can go out, who knows how to talk to people, who knows how to gather information. I'm a lawyer, I do capital cases, and I remember, just for example, talking to a mitigation specialist about this, and she's like looking at me and like, I'm like, what? She goes, it's obvious, he has lead paint. He ate lead as a kid. It's lead paint poisoning. And I had no idea as a lawyer that was the case. But you have somebody who is trained, who understands all of the mitigating factors and what has a professional interest and a professional degree, not always a degree, but has knowledge of what the records show, who the client is, what the many mental health issues are. A mitigation specialist is really a very important, and I would say absolutely necessary person to have in these kinds of cases. And finally, you don't have to have them on your team, but you need to have an appellate lawyer involved in your cases because there's this parallel. In fact, in Florida right now, the prosecutors are basically arguing in the appellate courts, look, all you have to do is get rid of the mandatory nature of parole, give kids life with a possibility of parole after 25 years. There's a lot of litigation going on as to whether the Supreme Court can do that, or whether that's actually the court legislating, which of course they can't do. So there's this huge fight going on in the appellate division, or in the appellate world. And then we trial lawyers are going in with mitigation cases. And so I think it's important to have an appellate lawyer, be thinking about how this case is going to look when it goes up, and to give you clues in what you need to do and what you don't need to do. We talked about this the last session, but a couple of things you need to know. There are some significant differences between capital cases and juvenile cases. For example, mental retardation, mental illness, child abuse, those can be very helpful when you're representing somebody who's facing death. They can be harmful if you're trying to get a kid out or get him a sentence, and less than life without the possibility of parole. Finally, let me talk about preparing for an actual hearing. Paul's going to go into much greater detail than I am, but I will tell you that preparing for a hearing is good in many ways. One is that it makes you work and it makes you think, and that amount of work and that amount of thinking is something, at least in my jurisdictions, that a lot of prosecutors don't want to do. So as a practical matter, it helps you get them to agree to some sort of plea. And a negotiated plea in these cases, at least in terms of the Graham cases, and I think it's similar in the Miller cases, is a way that you want to go as often as possible. For example, I have a case where I have a child who was sentenced on a felony murder rule. He was the getaway driver in a car, and he was 15. Wasn't licensed to drive at 15, but he was the getaway driver, and there was a homicide committed by an adult offender, and he was sentenced to a mandatory life without the possibility of parole because he was convicted of felony murder. That's very different than a 17-year-old who kills 3 people when, a week short of his 18th birthday. So there's a lot of variation, and I think with that variation, you want to go, obviously, with the best factual cases first, and the best judges, the best prosecutors, etc. But you need to be thinking about the very subtle differences and the very obvious differences in the cases that you're dealing with. You need to speak with your client a lot. You need to get releases signed by your client. That's another thing. You need to gather all the client's records. Paul will talk a little bit about that. All the records that you need to get and why they're relevant to the sentencing. you need to speak to people within the prison system. I would say the two most important experts that you need in the Miller cases are a child and adolescent psychiatrist or psychologist who understand the many ways in which kids are different, and they will be able to testify not only about that, but they will be able to testify about how different this person is now than he was when he was a teenager. That's very important. The other witness I think that's very important is somebody who can explain and what happens to a person when he goes to prison as a youth. He will be able to talk, or she will be able to talk about how they may start out with a lot of disciplinary reports, but eventually they grow out of that. They get more comfortable. They will be able to talk about what these disciplinary reports mean. In other words, you have a client who has, say, 50 disciplinary reports. That, the prosecutor will look at that and say that he's never grown up, he's never done anything good. But you sort of see the disciplinary reports as well. He didn't move when he was supposed to move, or he was trespassing. That's one we have a lot in Florida. Meaning he didn't move from one room to the other room as quickly as he could, and the guard was ticked off at him, so he gave him a trespass, DR. That happens a lot. So you have to be able to differentiate whether it's a serious or not a serious disciplinary report. But you need to have an expert witness who can testify about all those different components of his prison life and talk about what prison life is like and how well this person has done. And those are the two most important experts, but depending on the case, you may need other ones. Another thing you want to do is you want to get all of the positive things that he's done in prison. Notwithstanding that he was sentenced to life without parole, he's gotten a GED. He's gotten these different certificates of recognition. All of that is very important to present. And then, of course, you need to speak with family members and friends and ministers who knew him then and who know him now. And hopefully there's some people that have been with him all along and have seen him change, have seen him get better, have seen him mature, have seen that he is a much different person and can testify about little snippets, which is also very important in these cases when you're able to make it a narrative. You're able to talk about how he was at the time that this happened, all the bad things that had happened to him, and how he has matured in a very powerful way. And I think having lay witnesses testify to little nuggets of that is very powerful. It's far more powerful in some ways than an expert testimony, but the two together, I think, are very powerful. And what the mitigation specialist will do is they will gather information like his prenatal history, his developmental history, his family history, his medical history, any past psychiatric history, his social history, educational history, any drug and alcohol abuse, and why he was doing drug and alcohol abuse. And all of that, you need the mitigation specialist to gather all of that and more, because then they will come up with all the mitigating factors that were at play at the time of the crime. And in addition, the fact that he was a kid when all of this happened. That can be a very powerful 1-2 punch, but you need to be able to gather all of that information about your kid so that you can then figure out how to actually present it to the court or the prosecutor. And you also, this is something that as defense lawyers, I don't think you're really used to this, but I think in most sentencing cases, we don't have our client talk about it because we're appealing the case. And so at the actual sentencing, very rarely does our client talk. And even if we want our client to talk, as an adolescent, he's scared, he doesn't talk very well, and he's not going to come across very well. But on a resentencing, you need to seriously consider having your client talk about what he did and how badly he feels. Address the victim's family if they're there in a very conciliatory way. Have him be able to articulate what he did, why he did it, and he now understands the effect that had on the victim's family. And that can be very, very powerful testimony. That can move a judge, it can move the victim's family. It can even move a prosecutor. And you really need to express and explain that the person that's now before you, Judge, is really not the person that committed the crime X number of years ago. That person was a kid. And you need to explain, again, that he didn't take the offered plea because of his limited understanding, because he was predisposed to peer influence. He didn't want to appear like the chicken who pled out. I mean, I have this with young people all the time. They're offered a decent plea, but they won't plea because that would be the wrong thing to do. You just don't do that in the hood. You don't plea out. It's a wrong thing to do. You're betraying your friends. And that is a very powerful thing that kids feel. And you need to be able now to convince them that they understand that in a different way. How and why he's changed over the years. And again, I go back to quoting from Roper, Graham, and Miller. I believe it was Graham, they say that maturity can lead to that considered reflection, which is the foundation for remorse, renewal, and rehabilitation. Those are very powerful words. And I think you need to use those words and say, Judge, that's exactly what we have here. We have a kid who is matured, and he now is able to reflect considerably. He has and that's a very powerful foundation for what is obviously his remorse. And this kid can be rehabilitated. He has become rehabilitated. And you need to give him a second chance. You use that fact that this was a kid to your advantage. You start out at a disadvantage, but if you can convince the judge, the prosecutor, that this is really a very different person, then you have this whole concept of redemption, which is sort of, at least the Supreme Court buys redemption. But in Florida, redemption is irrelevant. You commit a terrible crime, you get sentenced to life without the possibility of parole, end of story. But it's coming back into the system. And I think that that's a very powerful way. And frankly, this is just a little bit of an aside, but I had a case, we talked about this before, it's a Graham case, but the first thing the prosecutor said in open court was, Judge, this is the worst case I have ever prosecuted. What this kid did, or what this young supposed kid did, he said supposed kid did. He wasn't a supposed kid, he was 15, but that's how he put it. The supposed kid shot and permanently damaged a beautiful young girl because he was working for a drug dealer, and he was aiming at another guy who he wanted to kill because he was on his turf, and instead he shot this little girl whose life will never be the same. And I got that prosecutor over time, and he never again had dealt with kids in the same way that we do. I got him to actually invest in the kid and to say, okay, I'll offer him a plea of 30 years, which turned out to be he would have another 5 years to serve in prison. And he actually said, I hope this kid makes it. I hope this person makes it. So it was changing that, and a lot of that had to do with explaining to him and having the client explain to him what it was like to be a kid and what he was thinking at the time. And the last thing I will tell you, and then I'll turn it over to Paul, is that it's very important, if you're in an actual sentencing hearing, that you prepare a sentencing memorandum. It will put all of the factors that the court needs to consider in an order and of importance and in context. And B, it will get you to think about all the different components of your case and of why this person should be sentenced differently. And it's part of the record. And I think a lot of these cases are going to get litigated, and the judges are going to be predisposed, obviously, to sentence him to life without parole again. But I have found that preparing a sentencing memorandum is very effective in getting judges to think differently. Paul?
All righty. So good morning, everybody. I'm going to basically be getting a little bit, and I think then we're going to start, I guess, go back and forth, get a little granular on exactly what's needed. A couple of maybe opening remarks for me would help here. I have after doing this work for so long and working, and I'm fortunate enough or unfortunate enough to have worked on homicides in probably 35 different states over the years, because I work a lot as consultants to attorneys on working up homicide cases. One of the things I've seen time and time again, it seems to be true, is that most of these kids, especially under 16, but all the way up to 17, really have a significant trauma history. While we've been talking about, Roper and Graham and Miller, for me, one of the cases that really talks about where these cases really started out is the Thompson versus Oklahoma, which was the Supreme Court's first case that really dealt with this, dealt with the whole issue of decision-making with kids, why kids are different than adults. And I have a bias, I think, as a result of Thompson and the progeny of cases on looking at trauma in the kid's life. So a lot of things you'll hear from me today will be looking at trauma. And it's not just trauma, but it's also looking at what I call, and this was a phrase used back around, I guess we're dating ourselves, you're talking about Thompson, but what they call developmental infirmities of kids, why kids are different. And when you go before a court, I think you can tell the judge, not only is it the United States Supreme Court, for instance, in Florida, I mentioned this before, I had a murder in Florida last year where I brought this up to the court. Not only does the Supreme Court recognize it in a homicide case, but if you look at how states around the country are dealing with normal kids, look at the motor vehicle laws in most states. In every state in the country now, as a result of research that was done in the 80s and 90s, the National Highway Safety Council and a number of universities, they started finding out that kids were getting killed in car accidents at higher rates because there were other kids in the car and because they were allowed to drive at night, et cetera. And they looked at a number of factors and realized that kids are influenced by their peers, kids lack consequential thinking, and kids will basically, and I think you can use this, will do stupid things. Now, when you're driving a 5,000-pound piece of metal 60 or 70 miles an hour down a side street, that really gets the public's attention. And when tragedy after tragedy after tragedy comes out, where you see kids, high school kids who everybody knows, wrap their car around in a tree one night on prom night. No, everybody knows those stories. And there's always a call after those things happen for what do we do about the motor vehicle laws. I think we need to transition our argument to looking at the whole general population, how that shift is made in the whole general population, and even in uber conservative legislatures, even like Florida, which has major restrictions, right, on when kids can drive, how many kids can be in the car. I know that's true in Oregon, and it's something that viscerally affects, and I believe, prosecutors and judges because they can't disagree with it. So when you say the Supreme Court has cited this legislation, and yes, Your Honor, we even see it in our own state. So I guess I recommend, people think it's a little corny maybe, but I really recommend looking at the history of your development, and I did it in one state, of the motor vehicle laws with regard to kids. Anyway, that's sort of my opening statement with that. Another thing I would say, and hopefully maybe here we could develop it for you or through some of us who presented, I think it's good to develop a checklist, which is basically digesting Thompson all the way through Miller of the factors that the Supreme Court has talked about. So you have a checklist that you can go through, and I'm going to talk about that in your interview with the clients, in looking at your records, and especially preparing your expert, because you need to take a major role in educating your expert. Unless it's a familiar person who's been around kids a lot and has testified for you before, you're going to end up having to use people perhaps who have an experience in adolescence, but they don't know what the decision says. I would arm every single expert with, and I wouldn't give them the Miller decision per se, but I would go through, and I think if we can develop, maybe, I don't know, Steve, maybe we can develop one or two pages where we can look at all the factors. And actually in Thompson, there was a great chart. Dorothy Lewis at that time, who was at NYU, one of the great researchers in juvenile homicide, one of the pioneers really, did a chart of I guess it was I can't remember now, 30 kids maybe who were on death row under the age of 15. I can't remember the number exactly, whatever it was. But you looked at all the problems that they had, and I think it's important that and I'm going to go through that now, look at that so there's not a lot of guesswork involved. Because right now we're telling you, and we can't go through all of the factors that are in Thompson through Miller. However, there are a number of distinct factors which you want to use as hooks to tie your facts into, and what I call it the vertically integrated presentation. So you can say to the court and not veer off of what the Supreme Court said and say, well, they talked about lack of consequential thinking. Well, when my kid got in the car with 6 other kids, X, Y, and Z happened. And that's why this list could be very helpful. Anyway, what I first want to go through is the client interview. And either it's going to be, and I think it's important for the attorney to get sort of a tactile sense of the case to do this, as well as obviously if you have somebody in your office, a mitigation person. And first of all, one thing we have to remember is we're using the term kids, but some of these guys have been down for 15, 20. I got a call from somebody who's 47, went in at 16. So I think, we're dealing with, grizzly old folks, basically, in some of these situations, because that's what you're going to look like even at 35 years old after you've been in prison for 15 or 18 years. And so I think we need to put their life history in context, and it's going to cause them to, and it's going to be more than one interview, because to get, as many of you know, when you're trying to get, and especially you see it in the death case, but if you're not a death penalty lawyer, you won't really have this experience of interviewing somebody in their mid-40s, 30s, even late 20s, right? And ask them what happened when they were 10, 11, 12 years old. They go, it's difficult to retrieve those memories. But what I'd like to do is, and I'm sort of, I do this in all my cases, I look first at the pre-incident family history, and I tell the person ahead of time, and if you have a mitigation person in your office, you can, I'm sure they're terrific and have their own skills, but I think it's very important to divide between pre-incident history, description of the homicide, and then institutional history. So, because typically if you go in during these cases, people have a million different things they want to talk to you about, and I think it's very important to get grounded. And when the pre-incident history is, and I'll make available, though I don't have it now, but I'll make available this is in a written form as well, and send it to you guys here, and then we can put it up as well. I think that would probably be good to help people out. But pre-incident history is going to look at history of abuse. And the history of abuse is broken down into a couple of different categories. And again, I have a strong bias because I do believe that if you look at all the research on child abuse, and you look at the research on the neurobiological effects of child abuse, you see that it does have a serious consequences for the already, when I'm not using this word being critical, but the already impaired or less than developed maturation thinking, consequential thinking, and impulsivity that teenagers have. And I would cite to many of you some of the work of Dr. Bruce Perry in this area. But you look at the history of abuse, and what I mean is not just the child abuse, not just sexual abuse or physical abuse, but one thing that's very important you find in the lives of these people is the witnessing of abuse. And in many states, the child abuse scheme defines actually witnessing child abuse as being, and witnessing domestic violence as being in the same category as being as a direct physical or sexual or emotional abuse. And in some instances, it's even, could have even a more deleterious consequence, because if you combine both the witnessing of violence with the actual physical experience of being assaulted, it creates a double whammy that makes that has many more deleterious effects on the child's development. The other thing I ask about are histories of head trauma, and that's all I really go into, because that's going to give you an indication of whether or not you want to get a neurobiological testing done, because you know obviously we're going to have some limited resources here. So if you're going to have you have a psychologist, let's say, and they're going to probably do a certain testing. Not all psychologists do neurological testing, but you probably want it done, especially if you have any kind of history of head injury. Now, unfortunately, a lot of our clients come from homes where there's been neglect, and you'll find that they didn't, bicycle helmets definitely were not in the picture, but they did have, you get a head trauma from being hit, head trauma from just accidents, no seat belts in the car, those kinds of things. In addition, whether or not they know it or not, and you'll then be able to cross-reference this either through family interviews or through records, whether they have FAS, fetal alcohol syndrome, where there's the lead paint issue that comes up, whether there's a case I just had, a methamphetamine, all babies. All of those things can come up, and that's why you want, when we get to the records part of it, you want to try to see if you can get the birth records or the hospital records of the child. Again, also, or the individual. Substance abuse. Was the person using drugs or alcohol at the time or prior to the homicide? Then you want to look at the final category, what I call major environmental/life traumas. That is death of an immediate relative, death of a friend, having a parent who has a debilitating long-term disease. Looking at whether or not a sibling has been lost, even if whether it's an accident, whether it's in the context of a crime, whether it's in the context of somebody who is in one of the numerous overseas wars we've been in the last 20 years. Then, of course, comes and as you're going through this, again, this checklist, and you don't necessarily have to wait for us to send you anything, though we'll be writing something up, but reading those cases and just literally copying and paste from the website and looking at all those factors and trying to see whether or not some of the factors you've gotten here predated. Because what I find is very persuasive for courts is if you can find pre-incident factors that are similar to what's enunciated in Graham and Miller, et cetera, that really show clearly that we have this, that this person fits into that category. Then there's the description of what happened. The description of what happened has the A and B part. The A part is what I call the 5 days before, week before events in the person's life. I always like going back because sometimes if you ask somebody about a homicide, they'll only tell you about what happened, usually, that day, or, and that's it. They'll just tell you, I got in the car and blah, blah, blah happened. Or he looked at me wrong and I pulled it out and I shot him. Whatever happened at that point. But you want to find out what happened earlier in the week, because sometimes you'll find there was some level of trauma, something that happened that contributed to the impulsivity, contributed to the depression. One thing we know with interviews of kids who've committed homicides is they have what psychologists will term at that time a tunneling affect. That is to say, they see a lack of, not only are there a lack of options that kids see when they commit the homicide, that's related to their impulsivity, but they actually see, if you ask them about the homicide, they'll say they really just saw the situation, just saw the person, and they see cloudiness or some sort of darkness around the situation, and they only can focus in, and it's not even that such a great focus on the event as it's happening. So sometimes that's affected by what's happened recently in their lives. So when you talk about the homicide, and I'm going to go into 3 typologies of homicide in a minute, one of the things that, and Steve and I talked about this before, one of the things that you'll find in probably, 80% of the cases, 75% of the cases, that the kids committed these homicides in conjunction with somebody else. Somebody else was there. Just like when kids get into car accidents, there's usually somebody else in the car, especially fatal car accidents. And so very rarely do you read about, you just anecdotally, you very rarely read about kids getting into single car accidents by themselves. I mean, remember the last time you heard that versus number of kids being in the car. So one of the problems, of course, but it's also an important fact for you, is to find out who else was there and the person's relationship, could be a child, to those people in the car. Obviously, it's especially important in the gang context. They're also their position if they were in a gang, and we know a substantial number, not substantial, but a portion of our kids, depending upon where you are have gang affiliations. Were other members of the gang around? Were they with other members of the gang at that time when the homicide happened? Was there any goading, etc.? Because again, even though the prosecutor is going to go, really, you want me to believe that argument? It is important if they're 13, 14, 15 years old, because I think this argument works better for younger people than it does for people 16, or that's 17 years and 10 months, that they have a situation where they're, okay, I'll keep going, where they have a situation that they're being pressured by these peers. I know I've done some school shooting cases, and in those school shooting cases, it definitely was the circumstance that within hours prior to the shooting, the kid was talking about doing it, and then was said, "Oh yeah, don't believe it, bullshit. It's never going to happen. You're not going to do it." And the kids end up doing it. And the same thing is true with kids, showing a gun and then being goaded into, can you really use it? Because I find a lot of these crimes, though it's not being critical of our clients, but they're kind of idiot-related crimes. They do things because in the context, they think it's the right thing to do, but they're just being pressured by their friends, and if they had any ability to reflect on it as adults, they probably wouldn't in the same circumstance. So again, being around other kids is very important. The group cohort is very important. So there are three basic crimes, three basic typologies, and these typologies are important because it helps you evaluate your case. One book I would recommend if you're going to be going into this, if you have more than 5 homicides, there's a book came out in the late 80s, but I think it's still terrific. It's by Dr. Alyssa Benedict and Dr. Dewey Cornell. And Dewey has been a terrific expert of mine. I think he's still doing some forensic work at the University of Virginia. And Dr. Benedict, last I know, she might be retired now, is at the University of Michigan. But they looked at typologies of juvenile homicide. And they do affect, number one, these typologies. I'll tell you how the courts look at them, how the prosecutors look at them, and also relate to the kind of client interview you have to do, as well as I'll be getting into in a few minutes the kind of records. The first are the intrafamilial homicides, the ones that I'm perhaps most familiar with. Some of you may know my work with kids who kill their parents. I've done a lot of work around the United States on kids who kill parents who abuse them. I know there's a number of cases now of kids who did get life without parole where kids killed their parents, and the issue of whether or not the abuse was there or not, I think in some of the cases I've read and some of the letters I've gotten from inmates over the last 3 or 4 months, they've talked about some of the problems in their house that caused them to commit these patricides or double parricides, killing of both a father and a mother. But in these intrafamilial homicides, you'll find that these are people who killed their parents, their siblings, grandparents, or guardian. And typically, but not in all cases, in my experience, over 90% of the cases, you'll find some extreme levels of abuse or family dysfunction in combination with some long-term mental health problems, such as post-traumatic stress disorder that results from these situations, dysthymia, which is a long-term depression, and sometimes borderline personality issues. But these are what we call situation-specific homicides, and what that means is that if you look at the person's pre-incident history, and one of the things that's important obviously, and I'll get into that in the pre-incident history, is going to be if they have any a juvenile record. And I was going to get into that when I discussed juvenile records, but obviously the juvenile record in the pre-incident history is extremely important because it will show whether or not the types of offenses, for instance, if you can show, and I apologize for leaving that out, I was going to include it in the records, but I think I probably should include in this part as well. But in any event, so if they have a juvenile record, it's important to look at whether or not, and this is going to factor into this typology, there's an ascending level of what they call conduct disorder-related activities or aggression, or there's nothing. For instance, they're committed status offenses, or they're like skipping school, not listening to their parents, that kind of stuff. Or did they start out with bump and grab school lunch money, and then there's an armed robbery at 16 and a half, and then the homicide happens 6 months later? So, so this first group of intrafamilial, you'll find very, very rarely there'll be any sort of pre-incident violence, and most you'll have is like skipping school, some drug-related arrests. And it's important, that's why, and I'll just bungee jump a little bit, in the records, because you'll be able to tell by looking at the early juvenile records, when you get them, whether or not in the disposition that was done, whether or not they found that there was any kind of what the motivation for whatever offense it was. So that's why you'll get some sort of informal or sometimes formal evaluation in those early juvenile records. The next form are what I call interpersonal homicides, a little different, and those are really people who kill people who they know in their lives in what I call the second circle. And that would be teachers, neighbors, friends, people they come in contact with on a regular basis. Again, you'll find a little bit of a bleed of that kind of history from the intrafamilial. You'll find that there is something in the relationship that caused the homicide. And to that extent, it's not necessarily going to, it's like they abuse them, but there's something in the relationship, and it's important to really dig deep to find out whether, when the employer was killed for, let's say a case of a teenager who killed his employer in a grocery store, find out about that relationship, get those, obviously those employee records, what happened there. And those cases, I think, tend to be, also have a greater, I guess, field of explanation to them. The last one are obviously the most difficult, which are homicides in conjunction with other felonies. That is drug dealing, kidnapping, robbery, even what we consider, drive-by gang-affiliated or gang-affiliated shootings. And these are difficult cases. What you'll typically find in these cases, however, is this ascending level of aggression within a year, 2 years prior to the homicide, and that's what a lot of the research reflects. Again, and also with all three categories, you'll find that they would not done, except for the first category. Intrafamilial, you'll often find single shooter kind of cases, single perpetrated cases. But with the shooter, especially with number 3, the homicide in conjunction with the felony, you will find that they did it in conjunction with somebody else or with a group of other people. And to that extent, that's where that argument I gave you before, but looking at your motor vehicle laws and other laws that relate to congregations of kids, even the laws that look about, you see this sometimes in downtowns, where curfew laws, not allowing groups of kids to get together, because though we all have our opinions on whether those are constitutional or not, the purpose of them, at least that we can argue to the court, is that groups of kids together are up to no good, and we can probably take something we disagree with and use it to our client's advantage. The next area that you want to look at, in addition to these three typologies, is you want to go into, and I forgot to mention this before, you want to go into the familial history. And that is whether or not the parents have been arrested, whether or not the parents, or the whole divorce, etc., type of history, whether the parents have been arrested for any offenses related to hurting other people in the family, whether they have prison records. Those also affect how, again, the person is viewed in terms of their, whether they had and judges may turn their eye at this, what kind of environment did they come out of? Then, of course, is the institutional history. Now, the institutional history, as Steve talked about, is extremely important. I would do the institutional history twice. I do it once before I get the records from the institution, and I do it after I get the records, because sometimes you will be able to get sort of a organic recitation of what happened from your client about what happened to him inside, and then you can go back and ask him questions because you already have then a baseline of information of what happened. I would do that as opposed to just do it all when you get the records. And let me just go into the records now just a little bit, and I will come back to the institutional issue in a second. Well, actually, let me do this. Because I guess I don't want to overlap there. Within the institution, I think when you do this interview, what you want to do is you want to ask them if they've had problems in the institution. You do want to find out what were those problems about. I mean, if they got write-ups, why were those write-ups there? Because what will sink these people, unfortunately, and Steve and I spoke about this in our first call in preparing for this webinar. Love that word, webinar. Was the fact that the institution creates a whole separate life of survival and of coping that predated the homicide. And so the person can get dinged by the prosecutor, dinged by the judge for what they did inside that has absolutely nothing to do with what happened on the outside. Now, sometimes they'll say, well, they just are repeating this pattern of violence on the inside. Now, we all know if you have a homicide, or aggravated assault, or any kind of homicide obviously not more than one, but any kind of serious bodily injury committed inside, you're going to have a long road to hoe in terms of getting a resentencing. And I think that's just the nature of the reality that I think even somebody coming to you will know about. But the kind of write-ups that are there, I think it's very important that you get, first of all, arm yourself. Now, Steve is really conversant with, obviously, with the prison rules, but you need to get yourself a copy of the disciplinary rules in the institution, if you don't already have one, so you can be able to explain, especially if you don't do much post-conviction work, you want to be able to explain to the court what this write-up actually meant, because unless you have like a key, you're not going to know what they meant. And so like having contraband, that's a big one. Contraband can be a book. Contraband can be having an extra hard-boiled egg. But and if you have a hungry, I remember interviewing this kid, he said, I was hungry all the time, and I took food all the time, and I got wrote up all the time. Put in that context, if you just look at ding, 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 that's really bad. But if you find out about why the person was taking the food, is it good? No. But is there an explanation that can help you out? Possibly, yes. Better to offer it. And so within the institution then, if you can show that the types, and this is really important, if you can show that the types of behavior he or she had in the institution kind of mirrored their behavior, and this is actually true sometimes of the category ones, the intrafamilial homicides, and also a number of the interpersonal homicides. What they did beforehand is kind of mirrored a lot what happened afterwards, and that would be great if you can make that tie-in to show, Your Honor, the person is pretty much the same kind of person. They've been an obedient inmate. And that, if you get those cases, it's the cherry on the pie. And that's why you want to be able to use and argue by the negative that these records show that your client has a consistent behavior. And this homicide was a unique, though tragic, valley in their life. So in terms of records, let me just run through those in the next few minutes here, and then we can talk. Obviously, educational records. One thing when you request records, if you don't have a mitigation specialist, you want to make sure when you request records you get both the academic, the grades, which are, who really, they're okay, but that's not the important part. That's not where the juice is. The guidance counselor records. 5 minutes? Okay. Okay, some questions here we can look at. But also, if they have IEPs that are called individual educational plans or 540 plans, that is, people who have developmental or learning disabilities, those are a treasure trove of information, of getting sort of free psychologicals that you can weave in and give to your expert. Foster care records, those are a little gnarly to get. So you have to sometimes, because Department of Social Services and Human Services sometimes belie their names, and you need to be able to, you have to sometimes subpoena those records. Usually a HIPAA or a typical records release is not going to work. and you need to subpoena those records, especially if they're foster care records, because they say, well, we have to redact them because there were other, I don't know if you face this, there are other kids' names in the family on them, and there were reporters. And I think those are records that are very, very, very important to get, especially if you read Thompson and its future progeny, all the way up to Miller. So you want to get those foster care records because they'll show some of the trauma the kid went through. Health records. Some of these, a lot of our clients don't have regular health records, but see if you can get those pediatrician records, especially ones that are going to show whether or not they had FAS or any kind of lead paint poisoning, which does affect cognition and does affect, has clear demonstrable effects on the neurobiology. Obviously, as I said before, the juvenile records. Try to find those dispositional records, which are similar for those of you who don't do it, like a PSI, like a pre-sentence investigation. Those disposition records tend to be very good depending upon what county you're in. If they really cared about it, because especially if they're younger when they get them. And I would try to, again, you may have to subpoena these as well. You want to go back and get, if the kid was truant and was locked up overnight, or something happened when they were 11 or 12 and they broke a window and they were locked up and let go. But you want to try to get this, because sometimes the reports were written up, and sometimes the reports will say it's because of lack of family support, blah, blah, blah. So those are important. Again, I said the prison records are important. I went into that because it puts in context their whole lives. And let me just talk for a couple of minutes about the experts, okay? And then we'll answer those questions. So with the experts, to me, it's extremely important to make sure you get somebody who's on the high-ho in terms of trauma. I tend to like to go after experts if they're willing to do it, especially if you can say, this is just, I just want you to talk about children, who do work for the state in working up child abuse assessments. Because then when you put them on the stand, what you're basically doing is you're qualifying them, and they're not just saying defense, 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 defense. Oh yeah, I work for the state's attorneys for this case, I work for the district attorney, I work for the people in this case, testified. I would think and I think that's a general good thing for defense attorneys to do in representing adolescents, is to really spend some time, because a lot of times they're contract people, and they will be important in trying to get, they all want work, and unless they have some strong philosophical beliefs, they're pretty good in terms of elucidating some of these issues of trauma. But definitely you need, and I feel even people with PhDs in social work are excellent, but a psychologist or a psychiatrist, but you also want to be able to get people who know adolescent trauma, who are familiar with child abuse, who are familiar with, and that's why get this list. I think, well, I'm talking about this list, man, I hope we do it. So, but we want to get this list.
I guess I have to.
Well, now we have to do it. Okay, so we'll get this done. You want to give the list to the expert. This is what the court said. I'm happy about, I'm sure you have a lot of skill, but you're really going to have to, I need you to know this kind of stuff and be able to focus on this, and give them the hi-ho on that. The expert's going to need, and I'll just tick this out, they're going to need to explain the pre-incident history. That's why if you do the pre-incident history and you talk to the expert ahead of time, you say, did Johnny tell you about X, Y, and Z? Or did Mary tell you this? Then you can re-inform the expert, and then the expert, if they care about the pristine nature of their report, because their notes are going to be looked at, they can go back in and do the re-interview on those notes. But I never let an expert write a report in any case, really, but until I've spoken to them and make sure they have these sort of pre-incident histories. Again, they can also explain the typology, because they can tell you that the research does reflect that, for instance, in the intrafamilial homicide area, that those kids have a greater chance of rehabilitation, even though they're serving life without parole, than other categories of people who commit homicide. With the people who are even in the last category, the people who commit in conjunction with the homicide, they can talk to you about the importance of them being affected negatively by a death in their family. All the kinds of ways, as I said before, I have a bias with trauma. All these kinds of ways in which experts can talk to you about, trauma. Again, if there's any kind of history of head injury, you want to explore that as much as you can, because it could result with some helpful in some helpful information. You want to find out, though this may get a little too detailed for some of you, you want to find out the kinds of tests that they're doing. One of the problems of testing with somebody who's been down for over 10 years, that the other side will say, is that being in the environment of a prison is extremely stressful. Therefore, things like, if you look at the MMPI, for those of you who are familiar with it, and this is, or the trauma symptom inventory, you'll get spikes like on the 4, 6, and 8 scale. They'll tell you for showing the person's paranoid. Now, typically, those will also show up in victims of abuse. And so you want to be able to make sure that when the testing is done, that they're testing for post-traumatic stress disorder. I would reference everybody to the terrific studies that are coming out of the Departments of Veterans Affairs on post-traumatic stress. Many of the one thing that if there's anything, though there's not much positive, but there's anything positive that's come out of the Iraq and Afghanistan wars, is the PTSD research has just rocketed up. And I would recommend you to kind of look on the Department of Veterans Affairs website and look at those people doing that kind of research to talk to you about the traumatic effects of war, and how you could look at those traumatic effects of abuse and other factors in the people's lives which resulted in these tragedies. I think I'm going to basically stop there. Oh yeah, one last thing. I've even tried to pull this out of the hat. When the person's in the institution, find out if there's been any overcrowding lawsuits against the institution or any 1983 actions against the institution. Because I would argue that some of the problems they may have in the institution can be directly related to the federal court order that you see that said this prison was sued because of inmate overcrowding, which will cause more fights, cause more dangerous environment for inmates. So just check that out. It's a possibility, and it may not be true in every case, but I think it's worthwhile. Anyway, so that's it.
A couple things. We had a couple questions
Sure.
from folks. One is that I've had difficulty in obtaining records from a hospital and doctors after 7 years. Any recommendations? Well, my first recommendation, that's why you want to hire a mitigation specialist, because a good mitigation specialist, A, knows how to get those records, and B, won't quit until they do. I had a case, a capital case, in which our claim was that our client was bipolar, and the prosecutor's position was he was not. We had a mitigation specialist who found his grandmother's hospital records, having been told a million times that they no longer existed because the hospital no longer existed. She found them, and we were able to establish this very powerful chronicle of post-traumatic stress syndrome in his family. So that's my first answer, which is hire a mitigation specialist. But beyond that, I would think that you need to dig. Whether an investigator or mitigation specialist, you really need to dig to try to find those records. And don't take the answer of the institution, we don't have this, at face value. I don't know how many cases that I've done in death penalty cases where if you have somebody who makes a relationship with a person at the place where you're asking them to give you the records, they make a good relationship, that person will say, okay, well, let me check here. Or it's in a warehouse down the road, but let me go check. I mean, does those kinds of relationships, that kind of work, and somebody who is actually willing to go the extra mile to get you those records, that's my best advice. And you may not get them, but I think you can. They're more likely there than not there.
Well, if you've already filed your motion, they need and they're not giving you your records, I would tune them up with a subpoena and make it returnable to the court on a certain date. I mean, the state is going to get see the records at that point, but I think if the records are that important, that it's probably worthwhile subpoenaing the records and let them come into court and let them bring their attorney in to oppose the subpoena, because some of these, if the hospital you're referring to here, if the records you think are very important, then I think you need to you get a judicial subpoena, but subpoena the records. That's what I'm doing.
Another question, which is, I have clients who committed offenses in 1972 and 1981, and how can I compensate or focus when their records are probably gone, and there are few family or friends left? those again are problems. But I think another reason why you want to gather all of the records and talk to all of the people that know your client, I think you can begin to get a lot of information on your client if you get outside of the immediate family, and if you get more records then, and then you can, the good thing about getting all those records and all talking to everybody that knew the client, teachers, ministers, that they give you information that you can then use to talk to somebody else, and that triggers their memory. I have found in some cases you don't get it, you can't get it, but if you go outside the immediate circle and work and have a mitigation specialist to do that, you can get a lot more than you think you can. Anyway, we have another question, which is an
Let me just chime in on this.
Sure.
I think I always have the idea the hospital blew up and the dog ate all the records. So let's go with that one. In that scenario, what I think you need to do is to that's why the pre-incident history interview, that's why the is extremely important. That's why getting your psychologist in to or a mental health expert to do a full assessment of the person would be critical in that point. And I think you have to just make it up through the interview, through the interview process with people. I think you say here that if there are few existing family members and friends, then the best you're left with, if this person has a history of a juvenile history, and it goes back to 72, that means most of those people are not going to be around. And 81, you probably will find people who are around who maybe in the law enforcement system even, or maybe his probation officer or her probation officer. Look for those people to interview who may have known the person. I mean, that's the best you can do, is go to people, official people. I once found a probation officer who, we had records, but the probation officer was more helpful because he did the dispositional report for the person. So it is a difficult situation, especially in those older cases. But again, in that situation, again, what I would think would be important is, how has the person's record been since 72 or 81? So inside, that would be important to know.
Another question that we got was, do you have any suggestions? This was at the end of the last session, but I think it pertains to this one, is do we have any suggestions for experts and reports and studies on prison behavior that we can refer to and show that how the changes in behavior are similar to changes in development? I think one of the reasons why you want to get a child and adolescent psychologist or psychiatrist involved is I think they can do that. And actually, Marcia Levick, who spoke to you in the last session,
Sure.
and I are trying to organize a group of doctors to be able to come up with a protocol as to what is relevant, what is not relevant, what doctors who are evaluating these kids should be asking them, what they should be looking for, etc. But in terms of studies, I have to confess, I'm not aware of any, and that was something that I will look into and get back to you on. But that's an interesting question, whether there's studies as to how prison behavior changes and how that's similar to changes in adolescent development.
Yeah, and I'm not familiar with that. Somebody asked, there's a question, the title of the book I referenced. The title of the book is Juvenile Homicide, and it's the authors are Dr. Dewey, D-E-W-E-Y, Cornell, like the university, C-O-R-N-E-L-L, and Dr. Elizabeth Benedek, B-E-N-E-D-E-K. If you Google Dr. Cornell, you will find a number of articles he wrote about this. I also, if people want to email me at pamones@comcast.net, or just go to my website and email me, paulmones.com. I maintain a pretty good bibliography that I use for my Strickland affidavits. For those of you who don't do your job. For these articles on juvenile homicide, et cetera, and I'd be glad to share that with anybody.
One other thing, just real quick, I don't know how much, we got into this last time a lot, and we didn't get into that much this time, is that you need to have a checklist as well as to just procedurally how to get involved in these cases and how to make sure you get appointed, and how you need to make sure that all the kids in your jurisdiction who are eligible for relief actually have an opportunity to get to court and get relief. In Florida, as a public defender, we have to have them sign affidavits of indigency, which you would think most kids in prison are, but that's a requirement. We have to get appointed. As a public defender, we're not allowed to represent somebody post-conviction, but if they ask the court to get a public defender appointed, the court can appoint us, and then we can get back in for resentencing. And so you need to be thinking about all the clients in your jurisdiction. How do you get them? How do you get them back into court? What are the procedural problems? We also, I think it applies to Miller cases in the same way that it applies to Graham cases. We have a pleading which combines post-conviction relief as well as new sentencing, because it's now an illegal sentence. In Florida, it's called a 3.850 and a 3.800, but those are separate grounds, and we want to file a motion that gets them into court on both of those grounds. I think it's important to be thinking about that. I know one of my panics is that, do we really have all the kids in my jurisdiction who are eligible for relief? And the best luck we've had is working closely with the Department of Corrections in Florida, which fortunately, in terms of the records that they produce and all of the researchers that they have, they're pretty good about it. So what I have done, or what we have done, is that we ask them to produce all the records of people who went in under 18, and they do look at the crime, the original crime time, not the time they were sentenced, which apparently in Pennsylvania is a problem. They only look at how old they were when they actually went into the prison system, as opposed to how old they were when the crime was committed. And we narrow down who the kids are, and then we make sure all those kids are contacted by a letter basically saying, you may be entitled to relief, get in touch with us and we'll follow up. And then we get appointed. But it's very important to have some source and some method by which you figure out which kids are eligible for relief. And my advice is to overestimate as opposed to underestimate who those kids are. I've gotten probably 20 letters in the last 2 weeks from people who, when you look at it very carefully, they're not entitled to relief. But at least they're now writing me and telling me what their circumstances are and their situations are. So that's just sort of a little brief on what you need to do to get appointed. One other thing I was just saying, I'll let you talk, but one other thing is that I think trauma is a huge issue, certainly in death penalty cases, and it's something that we don't think about, we don't emphasize enough. But I'll just say that, and I think, Paul, you talked about that a lot, but I would tell you that you need to make sure that that trauma is put in a way, in a case where you want to get somebody out, in a way that is sympathetic as opposed to just confirms that this is a very unhealthy person and it may not be his fault, but I as a judge am not going to let him out because he's dangerous. You need to basically talk about that trauma to get the judge sympathetic to your client, and your client did a lot of things that he would now not do, but you need to say that in some way he's transcended that. Notwithstanding this trauma, he's now behaving well, all the different things that he's doing right, and you need to include that to the extent that you think that trauma would make him dangerous or whatever. You need to include that in the release plan. So you can deal with that, and it can be very, very helpful, and if you deal with it properly, it will be very helpful. But you need to be aware of the fact that it's two-edged. And so just make sure that it's a little finesse, but I think if you put it in a proper perspective and in the proper way, it's very helpful.
Yeah, I agree with that, and I think the question is going to be is how good is your expert? And in that context, if somebody has been sentenced in the last, let's say, 15 years, I would go back and just not get the record, but try to find if there was an expert used in the case. Go speak to that expert, because sometimes they haven't been permitted to, during the testimony, maybe they were limited in what they could say during the trial. Maybe the sentencing, since if it was a mandatory sentence, there was no ability for them to discuss what they thought about the person. So try to find us. We got a note here of somebody from 1972. There are some psychologists, psychiatrists still working from that period of time, but not a lot. But clearly you could find people from the 80s and 90s, and I would go back and find those people. The other people who I think could be helpful and I've found this at least with certain clients, are the counselor that the person has at the institution. Become familiar with who that person is. Every inmate typically is assigned a counselor. And find out who that is. Speak to that person, because you want to know what that person has to say, because number one, it'll give you some sort of way to check up on the reliability of what your client is saying. And you could find that there's a lot of perhaps positive things that the client hasn't told you. And maybe they could put, because once you get these records, and we didn't talk about this, but once you get the records, you want to put the records in some context. And the way you put it in context is you do want to have, before it gets the court way, the wagon's out at that point. You want to really speak to the counselor at the institution, and sometimes it's a deputy warden because they won't let you speak to the counselor, but and again, these are it's very, 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 very time consuming, because sometimes it means not just a phone call, but maybe it means to go to the institution. So in those situations, I would really recommend you developing that, because I found more often than not that sometimes the counselor may have a completely different view of the person than maybe their record reflects.
Yeah, I would just sort of end up by saying that these are cases that would take a tremendous amount of work if done properly. But there are cases in which you have these kids who are sentenced to life without the possibility of parole, who all of a sudden have hope. And some of them are going to get relief and some of them won't. But you can, if you do these like a death penalty case, plus it's a kid case, and all the components of being a kid, and you advocate, as Paul was saying, you get a checklist of all the different ways in which kids are different, and all the Supreme Court cases that have said kids are different, and the many ways in which they are. I think you can, again, change the judge and change the prosecutor's attitude. You can get some of these kids some seriously good relief. One last question. We have a client who is 16 years old at the time of the felony murder robbery, sentenced to life with no parole under that statute. Now, what sentence can a judge consider that statutory penalty is unconstitutional? It depends on the jurisdiction, I would suppose. It depends. In Florida, that's being litigated as we speak, but in Florida, the two sentences, depending on when you committed the crime, but currently the two sentences are life without the possibility of parole or death, neither of which now are constitutional as applied to kids. So what the sentence is an interesting question. Some people say that the court has the inherent authority when there's no law to sentence a kid to whatever it thinks is necessary. Some people, this is being litigated in Pennsylvania as well, are saying that, well, what you need to do is what they did in the death penalty in Furman, which is you go to the most serious lesser included offense, and that's what he should be sentenced to. In Florida, the prosecutors have a reversion argument saying, okay, let's revert to life with the possibility of parole after 25 years, because that was the sentence that was in effect prior to this one being found unconstitutional. There are problems with that. I won't go into that, but it really depends on your jurisdiction as to what the solution is. But they're all, that's the appellate component to all of this, which is fascinating to me, because while we're litigating and teaching you how to litigate a resentencing, there's all this appellate litigation going on as to what the solution is. I think there was in Indiana, the governor just said, okay, I'm going to commute everybody's sentence to 80 years. And then, okay, does that solve the problem? There's going to be litigation about that. But they're no longer sentences without the possibility of parole. Everybody's going to get out in 80 years. So there are all kinds of things that are still happening, which is, as I always say, stay tuned, because there's a lot more to go. But what we're trying to do is to get organized and to get people thinking about all the different issues, both resentencing issues and appellate issues, and to merge the two. It's fascinating.
Yeah, I won't have much to add to that.
Okay, well, we're done 5 minutes early,
Yeah.
but if there are any other questions, shoot it right now. Otherwise, we can say, okay, it's been a while, and we can stop.
Okay, great.
Okay, thank you.
Thanks, everybody.
I just want to say thank you to
You're
both
welcome.
of you, Paul and Stephen, for
You're
coming
welcome.
here and doing this. And I want to say
Thank you.
thank you to all of our, you probably can't hear me because I'm not speaking into the microphone. But I would like to say thank you to all of our partner organizations who helped in organizing all of this, the Juvenile Law Center, the National Juvenile Defender Center, and the Campaign for the Fair Sentencing of Youth. Let all your colleagues know that if they could not watch it live, they can now watch it on demand through the NACDL website. Go to the Resource Center homepage and it will show you how to do that. And please stay tuned for the next set of webcasts in this series. It will be September 25th and 26th, and they will address additional topics such as using all of this adolescent behavioral research and development research we've been talking about at all stages in the proceedings. Check back to the NACDL website when the times are confirmed. You can find out about those. Thank you for watching.